I think it's interesting to observe the last several decades of ANC governance and how the National Democratic Revolution has found expression in various domains of our society. And I think one of the most telling examples of this, and which I think vindicates your thesis that the NDR is so strong as a guiding principle of the ANC's governance, is this erosion of private property rights and the attempts to undermine Section 25 of the Constitution and private property rights protections through the Expropriation Act, the earlier attempts to amend the Constitution, which were ultimately defeated in December 2021 because it didn't go far enough. The EFF was not happy to support those measures in Parliament and to achieve the 2/3 majority needed to change the Constitution. So could you help us to understand how is the ANC embarking on this threat to private property rights? Why are they doing that? They make all manner of claims around correcting the original sin of the past, of inequitable land ownership. But what is underpinning these moves?
Yes, the ANC has been very effective in using land as a wedge issue, because obviously there was such injustice in barring black people from buying land in 86% of the country, which was done in 1913. You could still buy land if you had the consent of the Governor-General, the equivalent of a state president, and about 3,000 transactions did take place. But the overall prohibition was there, that as a black person you could not buy in most of the country. And so this kind of injustice clearly needed to have a factor of redress in order to make good for what had been done in the past. But the ANC had no interest in creating a new class of independent landowners or homeowners, because property rights really make it difficult for a state to have enough control. I think it was Friedrich Hayek who said property rights are vital to everybody, whether they own property or they don't. Because if there's one actor, particularly the state, that has control over all property, then everybody is vulnerable. It's only if property is owned by many different people that there can be the kind of freedom that you need for democracy to thrive.
Because you have a diffusion of power throughout society.
A diffusion of power where it's all concentrated in the state. Everybody becomes dependent on the state to be able to use, to occupy land or other property that they need for various purposes.
And he who controls the state controls the people there.
Yes, exactly. So the land issue was used because it was emotive, because you could easily build support for it. And reforms were put in motion early on. You had a redistribution thrust, a restitution thrust, in terms of which people who had been dispossessed of land after 1913, through the forced removals in the 1960s and so on, could reclaim land. And so we had about 80,000 claims lodged. And through redistribution, the ANC bought land. Initially, the idea was that they would actually transfer it to black people. But as the NDR progressed, so the idea was that they would hang on to it within the state, and they would allow black people only to become leaseholders, that they could rent, but they could not own. And this, of course, was a great disappointment to many black people, and there have been stories of great hardship with somebody like David Ruchase, very successful black farmer, promised land in 2002 before this policy of lease only had really crystallized. And then denied. The promise was just broken. Until 17 years later, in court action, he was finally, the state was forced to honor its contract with him. So we had a land reform program, but it wasn't generating what people most wanted, private land ownership. But the ANC was able to say, almost no progress has been made. Clearly, it doesn't work if we buy land on the open market. What we need to do is to have the power to take land without paying for it. We need expropriation without compensation. And Section 25 of the Constitution is a barrier to that. And it's a barrier to that because it says that there must always be just and equitable compensation on expropriation. And there may be some very rare cases where property truly has no market value and you could pay almost nothing for that property. But in most situations, you'll be taking property that does have a market value. And what the ANC was now talking about was absolutely nothing at all. And the attempt to amend the Constitution to allow this failed, as you said. And it was primarily because the ANC didn't have a two-thirds majority on its own. It needed the support of the economic freedom fighters. And the economic freedom fighters wanted the state to have control over all land. Not necessarily ownership, but control. And you can get control through custodianship, which is a sort of variant, as it were, of ownership. Very much the same idea, gives the state all the same powers that really matter, of being able to decide how the land should be used. And the ANC thought that that could be upsetting to traditional leaders, that it could be upsetting to the 9.75 million Africans who own homes, very often without title deeds, but they see themselves as the owners of those homes. And now if they lost their homes into the custodianship of the state, it could be something that would weaken the ANC. So they said, no, we'll keep to certain land. Certain land has a terribly uncertain meaning. Perhaps it would mean all land in private ownership, you just didn't know. But the ANC, the EFF couldn't reach agreement, and so the amendment failed. And so we got Cyril Ramaphosa, our president, saying in 2022, it doesn't really matter. We can still get to expropriation without compensation via what was then the Expropriation Bill and is now the Expropriation Act. And indeed, it has a provision that says that the state can pay no compensation for land in certain circumstances. The list of circumstances is not a closed list, so it's simply gives some examples of where you might have nil. For example, where land is not actively being used, the idea is to hold it and perhaps in future to sell it at a profit. And if you have land in that category, then you might be expropriated for no compensation. Or where you have property, but there's been a land invasion and you've lost control of it, and you can't, according to the state, show that you've taken reasonable efforts to get back control, which is a very difficult thing to do the way the law is structured. So that's another example. But because the list is not closed, we really don't know how far nil compensation could extend. It does apply only to land. Does it apply also to the improvements on land? That's one of the great conundrums. We don't really know.
Good question.
Could a building also go for nil compensation, or is it land alone?
And if you've had your property forcibly taken from you by an invader, for example, and you've taken those reasonable steps, it's very difficult to evict somebody from your property under the Prevention of Illegal Eviction Act, the PI Act.
Exactly.
So that could actually incentivize
yes,
those kind
the
of
ANC
actions.
has structured that law so that it protects the illegal occupier rather than the owner. And you need a court order, it's difficult to get to the court, and really in many circumstances you can only get a court order for eviction if you can show that there's suitable alternative accommodation available. And municipalities very often can't provide that, and private owners certainly can't provide that. So it's hard to get the eviction order. And so somebody who has really just failed to navigate successfully through the obstacles set up by the ANC and the PI Act can then have the further loss of the property being expropriated for nil compensation and no hope of having any asset at the end of the day. But the other thing that is very important to recognize with the Expropriation Act is that it doesn't apply to land alone at all, and we can talk more about that. Secondly, that where it's not nil compensation, it's likely to be little compensation and not nearly enough, because the whole purpose of this act is to make it easier for the state not to pay market value. And of course, in terms of the Constitution, we know that market value is one factor, and other factors apply as well. Things like the purpose of the expropriation, the use to which the property is being put, but things which on the whole are very difficult to give a monetary value to. So the courts have tended to say, well, if we can't give a monetary value to it, well, then we can see what market value is, and that's what we think would be just and equitable. So the ANC is trying to move away from that approach and to put more emphasis on you must really come to an amount which is less than market value. And there are sort of mechanisms to help achieve that. The valuer general, this is a state official who, again, in the case of land reform, will decide what would be the appropriate value for both land, movables, herds of cattle, and so on. and has told Parliament that he could get the amount down to nil. His formula would allow him to get the amount down to nil. So people shouldn't be complacent, and they should also recognize that when the ANC talks about land, the Expropriation Act, like the Constitution, says that it applies to property really of virtually any kind. It doesn't apply to land alone. It applies to property expressly defined as not limited to land. So it could be shares, it could be movable assets, it could be patent rights, it could be mining rights, it could be a liquor license. There are any number of different types of property which will become vulnerable to expropriation for less than market value.
Yeah, I think that that's a grave risk. I think in these kinds of conversations around this debate, we often hear about the need for restitution. And I think that you need to compartmentalize those two discussions. Many countries do have expropriation law. There are, for public purposes, you sometimes need to build a highway or a dam, and that requires expropriation to occur. That there must be a recognition of, first of all, the market value of that property, but also the inconvenience that is borne by the expropriated party. This idea of a salatium, compensating people for the inconvenience, I think should apply. And it should be under very limited and controlled circumstances, not this kind of open-ended list. I mean, property held for speculative purposes, I think, is a perfectly legitimate reason to hold property. If you think of the Meir family in Midrand, they held their property for decades, and now all number of lifestyle estates and townhouse complexes have been built there. They've legitimately and justifiably earned a return on that speculative investment. And I think that that's very important. But the restitution debate, I think there's still an important discussion to be had there around where the state in the past has deprived people of property rights, as it did under apartheid, the 1913 Natives Land Act, for example, Group Areas Act, and other population control measures. Where people have been deprived of their inherent property rights, they should be compensated. And we have had a restitution process where over 90% of claims have been settled, and most of those claims, there has been financial compensation that has been given rather than land itself, which I think illustrates that many people actually crave a certain standard of living and maybe a more urban lifestyle. They're not necessarily wanting to live in a rural area, for example, on a patch of agrarian land.
Exactly. I think that's really interesting. And I'd like to come back to that, but to start with the earlier point of yes, there were injustices, there's a need for restitution, but we also need to look at what the Constitution says. As I mentioned, it's market value and there are other factors, but the overall test is that you must strike an equitable balance between the public interest in providing redress for the past and the interests of the expropriated owner, because it isn't fair to place on the shoulder of the expropriated owner too much of a burden of trying to make up for past injustices.
Especially where they were not themselves responsible.
They were not themselves responsible. And so you really need to make sure that the compensation that is provided is fair, that you don't do this thing of placing an unfair burden on a particular individual who is not culpable. And so in the older Expropriation Act, which is now being overtaken, there was also a recognition that people should get compensation for any direct financial loss flowing from the expropriation and the salatium, which is often quite a small amount, just because of the kind of emotional trauma that people might suffer from expropriation. So we mustn't lose sight of those factors as well. But what the ANC is hoping to do is to have a sort of fairly free hand to expropriate and pay far too little, what does not strike an equitable balance, and hope that the Constitutional Court will be sufficiently on side with the transformation project to allow it to do that. And it will also very much refer many of these disputes to land courts, which we should talk about too. But on the restitution point, yes, we had 80,000 or so claims put in for people who said they'd been dispossessed of land. We had a large number of successful claims. And then when people were given the chance between land or cash, they chose cash. And I think the ANC was dismayed. Gugile Quinto, who was our land reform minister at the time, said, oh, gosh, we don't have a peasantry anymore. We have an urbanizing society.
And saying that like it's a bad thing.
As if it was a bad thing. Because I think the ANC, in a way, perhaps has that very old-fashioned idea of a communist socialist society where you collectivize the land, where it's peasants that are now farming on the land, and they're organized into cooperatives, and the state is in overall control. And here was South Africans saying, we are an urbanizing society, and what we want is a job and a home in the city.
Yeah,
and you could see that with this far greater preference for cash rather than land. And it means that the ANC is always exaggerating the extent of the land hunger. And that's also confirmed by opinion polls over many years, conducted sometimes by the IRR, but other organizations too, in terms of which about 1%, 4% of black people will say that they see land reform as an important unresolved priority for the government to address. Most don't. Most want jobs. Most want the urban lifestyle, as you were saying.
Yeah, having said that, I think it is important to recognize that private property rights are universal, and they're not just an optimal public policy choice. They are inherent rights, an extension of your rights as a human being. And that's why we as the Free Market Foundation are very proud of our efforts with the Kaya Lum project, which is an initiative to extend title deed, full ownership of title deeds to over now 19,000 beneficiaries, where you have former tenants of council-owned properties. During the transition, the councils divested themselves of the ownership of these properties. The tenants then became the owners, but now they lack the title deed to prove their ownership status. That's where the Kaya Lum project has come in and closed that gap. And with private funders, we've been able to transfer 19,000 title deeds. And that really is an instrument of empowerment. That's giving you agency, just in the same way as cash gives you agency or an income from a job.